Hello, I'm Jessica Ryan Keeney. I am the Lassen County Department of Child Support Services attorney and the Plumas County Department of Child Support Services attorney. We are two very small counties in very rural Northern California. So this is the Lassen County Department of Child Support Services YouTube channel. Thank you for joining us. Please be sure to like the video, ding the bell so that you get notifications when we upload new videos. I have another question and answer video for you today. I already recorded it once and then I went to go edit it and bam, it was gone. So now I'm recording this on my phone, knock on wood. Hopefully this works better. And you might hear and see my son in the background. Sorry, can't do anything about that. Remember that none of this is legal advice. This is all for educational purposes only. It's your job to consult an attorney, not me, an attorney who's not me, about your case and make sure that what you're going to do in your case or what you're thinking about doing in your case is appropriate for your case. So this is for educational purposes only. I'm going to talk about what I've seen done, maybe what I've done, what I would contemplate doing, but that doesn't mean it's right for your case. But it's a jumping off point so that you can start to go have intelligent conversations about what your options are. Okay, this set of questions comes from our Statute of Limitations on Collecting Child Support Arrears video. So this question is, what happens if child support is in arrears from over 20 years ago? The child is now in their 30s and the receiving parent passed away. This is a situation for someone I know personally. Thank you so much. So in California, the age of the arrears don't matter because in California, child support arrears are due until paid in full. There's no statute of limitations on collecting. So the fact that the arrears are 20 years old doesn't matter. The fact that the child's in their 30s doesn't matter. Also, the fact that the receiving parent, the parent that was owed the support, has passed away also doesn't matter. So what I've seen in this case is I've seen the child for whom the support was owed get the support, get those arrears. Here's another one. Hello, I've been trying to collect child support for over 20 years. Can I please have some orientation and possibly collecting over $30,000 in arrears? So I'm not really sure what they mean by have some orientation. But basically it's the same answer as above. It's due until paid in California. So you can go to the Department of Child Support Services and they can help you collect. Obviously, I'm a little bit biased because I'm a Department of Child Support Services attorney. But, we do have some remedies available to us that private attorneys and private individuals don't have available to them. Things like tax intercepts. We also have our program programmed to be working behind the scenes. As it finds information, it's sending out garnishments and levies and all that good kind of stuff. Okay, let's see. Next question. Child support award from approximately 1976. Never paid. What to do? The child is 51 years old. So again, if this is a California order, same answer as the last two. Hey, look, here's my son. What's up? Next question. When we divorced, we agreed to use the child support calculation government website ourselves. We didn't have the judge assign a specific dollar amount to our child support order. So I can't get the child support office to go after him for child support arrears. I would have to sue him for them. Is there a statute of limitations for that? Well, I think we're missing some details here. Was there a child support order? You don't have to have the judge make the calculation in order for there to be a child support order. And if there was a child support order, then DCSS can go collect the arrears, whether the judge made the calculation or not. So in reading this, I'm kind of wondering if they didn't maybe have a handshake agreement and they didn't actually put it in their judgment that one parent was going to pay X amount of child support for the other. And so if there was no child support order, then there's no arrears and there's no statute of limitations because there's no order on which there would be arrears. I would need some more details to really answer that question, but that's kind of what I'm thinking might have happened in there. I'm kind of thinking it might have been a handshake agreement and not actually court-ordered child support. In which case, you can only get child support in California either retroactive to the date of filing the petition or retroactive to the date of filing the motion to modify. But here's the problem. If you file a petition for divorce or for child support or for parentage or whatever, you file your family law petition, and then you see the case to the end, like in this divorce, and you get a judgment, you don't get to go back years later and say, oh, I want you to make support retroactive to the date that I filed the petition. No, the judgment kind of cuts off your ability to go get support back to the date of filing the petition. So the best you're going to get, if there was never a child support order, is support retroactive to the date of filing the motion to modify child support, because essentially it was either a zero child support order or a reserved child support order, and reserving over child support for purposes of this discussion is the same as a zero child support order. So to get a moneyed order, that would essentially be a modification. So again, don't really know what's going on in that situation, but that's the best I can come up with based on what we've got. So here's the deal. Make sure, if you're gonna want child support, that you get it in the order. Okay, if it's good enough to be a handshake agreement, it's good enough to be a court order. Because if it's not a court order, you're not going to be able to enforce your handshake agreement. Next one, when does the interest in the child support arrears stop accumulating? In California, child support arrears are due until paid in full. And so the interest just keeps accruing. It just keeps accruing until those arrears get paid in full, and it accrues at a rate of 10%. It's kind of steep. Next video that we have questions for. We've got more questions on these videos, by the way. I just grabbed some of the more recent ones. Proof of service by email, aka proof of electronic service. So this is the video that's the video that these questions come from. So I'm not a party to the case, and I'm trying to serve someone who is homeless, and I've tried to meet with the person who is purposefully trying to avoid me. Through text, I have proof that he states that he will not accept the documents. I have emailed to his email address that he provided to the court on 3 different days. Can I print and send email proof and submit it with the proof of service form to the clerk? Again, not enough details to really answer this question. And, this isn't legal advice. This is for informational purposes only. But I see a few issues here. Number one is, does this person have to be personally served? Or can they be served by mail? And I don't know if it's the beginning of the case, it's the summons and complaint or the summons and petition, or it's an order to show cause for contempt, or, it's those are things that need to be served personally. Now, if this person can legally be served by mail, then whoever's trying to serve these documents doesn't really need to try to meet up with the person. Now, they said the person's homeless. I know plenty of homeless people who have addresses, so they could just mail the documents to the homeless person's last known address or address that this homeless person gave the court. This person may consider turning this over to a process server, or a private investigator, and let the private investigator or process server try to catch up with this person. Sometimes they're a little bit better at catching up with people who are hard to reach. The party to the case, the person that, this poster is trying to serve documents for, they may go to the court and ask for an order that they be allowed to have this person served by email. And if the court won't grant that, they might consider service by publication. Now, service by email would be a lot cheaper, so obviously I'd prefer service by email. But unless this person signed a consent for electronic service, or there's a local rule that requires people to allow local electronic service in this particular case, or there's court order, did I say that already? Or there's particular law that requires that electronic service be allowed, then electronic service isn't valid without a consent for electronic service or any of those things that I listed. Now, that being said, when I'm serving somebody by mail, I will often email them the documents that I'm serving by mail, and I will put on the proof of service the email address that I served them at, and then include that I served them electronically. So even though that's not valid service, when I do that, it lets the court know, that they probably really actually did get these documents. And so the, mail service in the situations that I'm dealing with, that's the valid service. But we have a lot of problems with the mail in our area. So then when the court sees that they also were emailed the documents, a lot of times the court's like, oh, okay. So if you didn't get it by mail, you got it by email. This is probably good. Now, different courts may view that differently. And then here's another thing. It says that this person will not accept the documents. Well, when it comes to personally serving somebody, the person who's being served doesn't have to accept the documents. You just basically have to walk up to them and say, you're being served. The documents don't even have to touch them. The documents can fall on the ground for all I care. So they don't actually have to accept service. If that's the party to the case who needs to be personally served. Just walk up, you're being served. That's it. Now they're served. I've got some stories. Maybe I should tell them in another video about people not accepting service. So again, not enough information to answer this person's question. And I don't know, maybe there was an answer in there. Oh man, that thing is cute. Okay, we're gonna see this little skeleton that my son built. So maybe there was enough, information that I just gave that I was able to answer that person's question, and maybe I answered questions for you guys as well. Next question. Who do we serve documents to? Their attorney? Helpful video. I'm so confused.
Mama, can you show this to them?
Oh man, that is cute. Check this out. So it's not quite a minifig, but it has a very minifig feel to it. That is super cute.
Yes, it is.
Okay, who do we serve documents to? Their attorney? Helpful video. I'm so confused. Sorry you're confused. Thank you though for saying it's a helpful video. So who you serve documents to really depends on the documents that you're serving and where you are in the case. Some documents have to be served to the party themselves, and service on the attorney isn't good enough. And sometimes you serve the attorney. So we need a little bit more details, but let me give you some examples. So beginning of the case, you're doing a summons and petition. That needs to be served on the other party. Chances are decent they're not going to have an attorney at that point, but I don't know, sometimes they do. Let's say that you're serving a motion to modify, whether it's custody and visitation or child support, and that motion is after judgment has been entered, then you are required to serve the party to the case. Service on the attorney is not good enough. Now, when in question, I don't think it hurts to serve the party and the attorney. I mean, the attorney is going to appreciate the courtesy copy, and if the party's represented and you serve the attorney and the party and you weren't required to serve the party themselves, service on the attorney was sufficient, the party's gonna appreciate getting a copy of those documents. Now, if you go get them personally served, and you weren't required to have the party served, they might be a little bit upset that somebody, sought them out to serve them when they weren't even required to, have the document served on them. Hopefully that answered the question. Okay, what is the form my ex has to sign to agree to electronic service? So the form number is EFS. That's Elephant Frank Sam -005-CV, as in Child Victor. It's actually as in civil, but anyway. And that form is called Consent to Electronic Service and Notice of Electronic Service Address. So I've been known in my private cases to fill this out the way the other party would need to fill it out and send it to them to help facilitate getting them to sign it. See, this one, I sat on a jury duty case that was rape of a child, and I just got a proof of service notice on my door. I have to appear in court. I don't know what this means or what to expect in court. Do you have any advice or knowledge on what this is? So I'll say that we don't have enough details for me to answer this question. I don't know why a person would have a proof of service on their door. That's not really something that generally gets served. It frequently needs to be served along with the motion or along with the summons and petition, but you don't generally just get served a proof of service. So I'm suspecting that this was probably a motion on this person's door. And, we don't know if this is a family law case or not. I mean, I'm guessing that because they're asking questions on this channel, it probably is a family law case. And, what to expect in court depends on the type of case it is. So if it's a child support case and it's a contempt, that is vastly different than if it's, modification of child support. So basically, if you get, legal documents on your door, or you get served legal documents, or they show up in the mail and you don't know what to do with them, you should open them, look at them, and go talk to an attorney. You don't necessarily want to talk to opposing counsel because sometimes there's a benefit to not. Usually in the cases I'm involved in, there's a huge benefit to talking to opposing counsel, but make sure that you go talk to an attorney, not me, another attorney, who can look at your documents, answer your questions, get you set on the right course before you go talk to opposing counsel. If this is a family law case, there is a family law facilitator in every county that you can also go to and get some advice. They can explain what the paperwork means and all that good stuff, and what to expect next. This next question says, the Courthouse Self-Help Center said I can email the documents myself, even if I'm the respondent. Email the plaintiff's attorney. So, the general rule is that non-parties have to serve documents. You've got to be over the age of 18 or over. Still the rule. And not a party to the case. But California Rule of Court, rule number 2.251, section F, service by the parties and other persons. 1, notwithstanding E, parties and other persons that have consented to or are required to serve documents electronically are responsible for electronic service on all other parties and other persons required to be served in the case. A party or other person may serve documents electronically directly by an agent or through a designated electronic filing service provider. So my reading of the California Rules of Court says that as long as electronic service is lawful or authorized in your case, then you, the party, can actually serve documents on the other side yourself. No more having to go to a non-party to the case. And the proof of electronic service, at the very top, it says I am at least 18 years old. So it used, like a proof of service of mail usually says I am at least 18 years old and not a party to the case. So even the proof of electronic service contemplates the possibility that a party to the case will serve the documents. And at first I thought this was kind of weird, right? Because I'm so used to over 18, not a party to the case. Well, 18 or older, not a party to the case to serve. But then when you really think about it, the whole reason for requiring a non-party to serve the documents is to ensure that they get served. You know, there's this whole thinking that like a party to the case may have some incentive to say that someone got served when in fact they didn't, whereas a non-party to the case doesn't have that incentive. But as I reason through this in that same way, and I think about electronic service, you know, if the party who was served calls into question, you know, the veracity of the statements that they can serve, that they were served, they can always require that the party who served them produce proof that they were served, you know, like, hey, print that email, prove it, show me the email. So, you know, when I think about it that way, it totally makes sense that when electronic service is authorized in a case, a party to the case can serve the documents. Next question is going to come from the video, what's a liquidation on arrears order for child support? And the question is, my ex-husband has arrears of $48,000 and Los Angeles does nothing. Los Angeles County does nothing. Does nothing is all capital. They act like they don't care. He works under the table for his father. So I end up getting $30 per month instead of the $900 he's supposed to pay per month. I've told them to investigate and they never do. Because how can he be living off of $60 per month since they take 50% of whatever he's reporting? What can I do? So first I'll say I'm very sorry that you're going through this, and I'm sorry that it seems like Los Angeles County doesn't care. I can assure you, they very much want to collect that money too. And, you know, you can tell them to investigate all you want, but they're not really set up to go investigate. And even if they do investigate, you know, they've still got to be able to collect the money. And so it's tough when you've got somebody working for cash, especially for a family member who's evidently willing to lie for them, because now you're dealing with two people who are hiding information. So unfortunately, in situations like this, the parent really needs to be the one to do the investigation, or the parent needs to hire an attorney that can hire someone to do the investigation, because yeah, DCSS just isn't set up to do this. I mean, there are times that I really want to go issue subpoenas. I'm like, oh, this would be a great case to subpoena bank records. And my client doesn't let me because we don't have the budget for it. Now, you know, I have been known to subpoena non-parties to a hearing. So, you know, I've filed motions and then I've had it set for evidentiary hearings, and I've done this at DCSS, and then I've subpoenaed witnesses who are not a party to the case. I generally like to talk to the witnesses beforehand to get a feel for what they're gonna say, right? And the reason why is because, you know, let's just take this case. Let's take Dad's dad. We'll call him Grandpa because he's the grandpa of the child. You know, if I call Grandpa and, you know, I start asking him questions about how much Dad makes per month and things like that, and I think he's lying, in my opinion, he's probably gonna lie when he gets on the stand, right? And then me asking him the same question 7 ways to Sunday is not going to create a come to Jesus moment where he is suddenly honest about everything. And my experience, people who are lying just keep digging in. Now, sometimes I can catch them on their lies. That's fun. I would probably want to subpoena employment records, time cards. I don't know that I would necessarily get any of that information. I'd like to have a conversation with Grandpa, most likely under oath. If I did a motion to say modify child support or set child support and I subpoenaed grandpa as a witness, I would be asking him questions like, how many hours per week does dad work? How much an hour do you pay him? What is his job title? What are his responsibilities? How do you pay him? Cash, check, electronic deposit. And then I'd be curious, do you have similar arrangements with other employees? And, if he weren't your son and were a stranger to you, would you have the same arrangement? Because I could envision a situation where grandpa's like, oh yeah, he works 40 hours a week, but I only pay him $60 a week or a month, which, would be totally ridiculous. The court would totally not find that credible. But then you still have the issue of you still got to collect the money, right? So you can issue an income withholding order, also known as an IWO, on grandpa. But, it sounds like that's already been done and DCSS is only collecting $30 per month. So it sounds like grandpa isn't withholding the required amount. You could do an employer contempt. Ooh, I've wanted to do an employer contempt for a long time. I always get so close and then something happens and it resolves and I can't do it. So yeah, an employer contempt could be done, but the problem is for contempt, you have to prove that there was an order, that the contemnor knew there was an order, and that they had the ability to comply with the order. So the law is pretty solid, and I'll be working on a video on employer contempt, and I'll go over this in that video. The income withholding order is an order. So there's your order. The employer knew about the order. Well, if the employer is sending in $30 a month, you can presume that the employer knew about the order. The employer had the ability to comply with the order. And here's where it could be a little bit difficult. So when you do a contempt, it's quasi-criminal. And the contemnor has a Fifth Amendment right to remain silent. So grandpa doesn't have to take the stand in an employer contempt. So if grandpa's not taking the stand and you're not getting information about how many hours per week dad works and all this other stuff from grandpa, probably gonna have problems with an employer contempt. Maybe subpoenaing some employment documents, getting grandpa to testify in a hearing about, how many hours per week grandpa or dad works and how much he's paid and all that good stuff like I previous mentioned before doing the employer contempt would work. I mean, these are tough cases because people who manage to structure their life so that they can be paid under the table and do everything in cash, so they don't have to put money in a bank account in their name. They've gone through great efforts to make it difficult to find their money. And it can be. I mean, they mess up from time to time. And I've seen some good mess ups before. But yeah, I am sorry, commenter. You have a bit of an uphill battle. And unfortunately, DCSS may not be in the position to do the type of investigating you want them to. Not because they don't want to, but because that's just not how they are set up. So there you go. That was the question and answer. And again, remember, none of this is legal advice. None of this is legal advice. This is for educational purposes only. It's your responsibility to go speak to an attorney, not me, someone else, another attorney, who can analyze your case and what you want to do and analyze what's best for your case and then proceed accordingly. That being said, we sure appreciate you tuning in. We sure appreciate your questions and your comments. They often make for good material for future videos, even though they're not legal advice. And sometimes you may get an answer in the comments, and it's still not legal advice. So please be sure, once again, thumbs up on the video, ding the bell so that you get notifications when we upload new material, and goodbye for now. Enjoy your evening.